Hello everyone. We have seen that law can be classified under two heads, international law and municipal law. The municipal law can further be classified under two heads, the public law and the private law. We have also seen that public law can further be studied under three heads, the constitutional law, the administrative law and the criminal law. The importance and scope of international law and the three classes of public law, that is, the constitutional law, administrative law and criminal law, have been dealt with in the last four presentations. The next four presentations will concentrate on exploring the scope and importance of the four categories of private law, the law of torts, law of obligation, law of property and personal law. Law of torts deals with civil wrongs and remedies for such civil wrongs. Law of obligation deals with obligations arising out of contracts, trusts, etc. Law of property deals with rules governing transactions pertaining to property, and personal law deals with rights and duties arising from personal relations between individuals like marriage, adoption, etc. This presentation attempts to introduce the law of torts. Now, what is law of torts and why is it necessary? In the day-to-day life of a modern society, men carry on business and compete with each other. They own property and exercise their rights over their property. They participate in a number of activities and these may incidentally interfere with the rights of others, causing injury to others. When the activity of an individual violates an other's rights, or when the law imposes a duty of care on one individual towards another and he breaches the duty and causes loss or injury to that other, the law has to provide some relief to the wronged. It is the law of torts that provides for adjustment of this loss or injury suffered by the wronged by providing him with compensation which is payable by the wrongdoer who was responsible for the violation of right or breach of duty. The law of tort therefore attempts to shift the loss suffered by the injured to the person who caused loss to such person. Now, the idea of justice through any public tribunal was not known to the primitive communities. Private vengeance and self-help dominated in such societies. Law was enforced by individuals whose rights were violated with the help of his family and clan. Even where a person suffered serious injury, which in the present times would be considered as a serious crime, only compensation by money payment was awarded to the injured person and his relative. Where the injured person died, his relatives were compensated. When the transition of primitive communities from their natural state to the modern civil state took place, the most important change that occurred was that the use of force by the individual was substituted by the use of force by organized community as an instrument of redress and punishment for injuries. Administration of criminal justice took the place of private vengeance and civil justice took the place of violent self-help. Thus, accountability under law, that is liability, could arise for a breach of contract, quasi-contract, for a crime or for a tort. Contractual liability is imposed for ensuring the performance of a promise. This is intended to protect a single limited interest between the parties to a contract. Quasi-contractual liability is created for preventing unjust enrichment of one man at the cost of another. Criminal justice is concerned with protection of interests common to the public at large. Hence, it is pursued by the state and is accomplished by punishing the wrongdoer. Law of torts aims at protecting the legally recognized interests of individuals, and whenever there is a violation of such legally recognized interest, compensation is required to be paid to the individual for the loss suffered by him due to such violation by the wrongdoer. Now, the next question would be, when will the law provide for compensation for an injury or loss? Is there any guiding principle to show when such compensation has to be paid? The answer would be that the liability should be based on the conduct which is socially unreasonable. Tortious liability arises when there is unreasonable interference with the interests of others. Thus, tort is a civil wrong, that is, violation of an interest recognized by law or a breach of duty imposed by law for which a suit has to be filed in a civil court by the injured party for compensation payable by the wrongdoer. Law of torts is therefore primarily concerned with the adjustment of conflicting interests of individuals in order to achieve a desirable social result. Law of torts can be studied under two heads: general principles governing law of torts and specific torts. Now, what do these discuss about? Under the general principles, the aspects that would be dealt with include the capacity to sue and be sued, that is, who can file a suit for a tort and who can be sued for a tort. General defenses, which enumerate the circumstances which, when proved, would exempt a person from liability. Vicarious liability, wherein the circumstances under which a person can be sued for the tort committed by another person would be discussed. Extinction of tortious liability deals with circumstances under which liability for a tort ceases to exist. And finally, what are the various remedies available for an action in tort would be discussed under remedies. Now, so far as the specific torts are concerned, the specific torts deal with various kinds of torts which can be broadly classified under the following heads. Torts affecting the person, which include assault, battery, and false imprisonment. Torts affecting reputation, which includes libel and slander, malicious prosecution. Torts affecting immovable property, which include trespass, dispossession, and injury to easements. Torts affecting movable property, which include trespass to goods, detention, and conversion. And torts affecting both person and property, dealing with negligence, nuisance, and fraud. This is an important branch of law which acquaints us with various legally recognized interests, rights, and duties, the violation of which would entitle us to bring an action in a civil court for compensation. Lack of awareness in this branch of law, lack of easy access to justice, and delay in judicial process are reasons due to which this branch of law is not as well developed as it ought to be for a country as vast and as diverse as ours. Thank you.